Madam President, after careful consideration and assessment of the nominee's record and expressed views, I rise today to express my opposition to Solicitor General Elena Kagan's nomination to the United States Supreme Court. In the nomination process, a telling and insightful statement by another senator is most applicable and I think pertinent. During the Senate's debate on the nomination of Chief Justice John Roberts, then Senator Barack Obama stated that while adherence to legal precedent and rules of statutory or constitutional construction will dispose of 95% of the cases that come before the court, so that both a Scalia or Ginsburg will arrive at the same place most of the time on those 95% of the cases. What matters on the Supreme Court is those 5% of cases that are truly difficult. In those cases, Senator Obama said, adherence to precedent and rules will only get you through the 25th mile of the marathon. That last mile, the senator said, can only be determined on the basis of one, one's deepest values; two, one's core concerns; three, one's broader perspectives on how the world really works; and four, the depth and breadth of one's empathy. Well, Madam President, I respectfully disagree with this rationale, and I find it troubling. It seems to me our judges must decide all cases in adherence to legal precedent, rules of statutory or constitutional construction. The role of a judge is not to rule based on his or her own personal judgments or comply with one's empathy, how they think the world really works, or concerns and values, deep or shallow, all subject to personal views, ideology, and the winds of time and political change. No, the role of a judge should adhere to the laws as they are written. An appointment to serve on the Supreme Court of the United States is a lifetime term. It was crafted by our founders to protect and insulate the highest court of our land from personal concern, empathy, individual values, or how one thinks the world really works at some point of time, not to mention the threat of any influence of politics. Nominations to the highest bench should therefore not be considered lightly. It is one of the most important votes a senator has the privilege to cast. And I would submit, compared to the standard of legal precedent, statutory rules, constitutional construction, again, personal values concern how the world allegedly works, and one's personal criteria of empathy represents a lesser standard, sort of a standard light. The qualifications of the nominee also must be carefully considered. As U.S. Senators, we have an obligation to ensure that our courts are filled with qualified, impartial judges. In light of that, I must ask, who is Elena Kagan? And in reviewing Ms. Kagan's qualifications, I find her lack of judicial experience striking. While others note that serving as a judge is not a requirement for a Supreme Court nomination, it has also been noted that every nominee in nearly 40 years to the Supreme Court has had extensive judicial experience, whether from the bench or as a litigator in the courtroom. Ms. Kagan's litigation experience is limited, with the majority of her arguments being made during her brief tenure as the United States Solicitor General. Now, given her obvious lack of experience in the courtroom, one must ask if this is the best position to receive on-the-job training. Will the craft of judging come innately to Ms. Kagan, or is it a skill honed by years of practice and judicial experience? Some have argued in defense of such a thin judicial resume that nominees can bring, again, a real world, whatever that is, perspective to the bench. Nonetheless, much of the nominees' experience lies in the hallowed Ivy League halls of academia. Indeed, that is a world of its own. Now, while I do not question the merits of a strong university background, I question how that makes one more in tune with the real world. Additionally, the nominee's resume includes her positions as a special counsel and policy advisor in the Clinton administration, a role in which she truly relished that job. During her tenure, she advocated for policies involving the Second Amendment. In response to a Supreme Court decision which struck down the Brady Act's requirement of background checks before gun sales, documents from the nominee's tenure suggested that the administration explore how to maneuver around the court's decision by executive action. The advice here goes beyond legal counsel and indicates a clear interest in achieving a policy goal by going around the Supreme Court decision while foregoing the jurisdiction of Congress. When determining how Ms. Kagan may approach a seat on the court, her position as a policy advisor is one of the few records we have available to review. Does this type of maneuvering indicate how Ms. Kagan would use her position as a Supreme Court justice to justify an agenda where a policy goal is the intended outcome? Madam President, I must also say that as Dean of the Harvard Law School, Ms. Kagan's effort to ban military recruiters from the main placement office on campus is deeply troubling. The justification for violating the Solomon Amendment, named after Congressman Jerry Solomon, was to protect the military's don't ask, don't tell policy. This action was also consistent with her own expressed views. It must be noted, blocking access to military recruiters is counter to federal law. Only when threatened with the loss of federal funding did Harvard actually comply. Ms. Kagan then used a stayed decision by an appellate court which determined the Solomon Amendment was unconstitutional to reinstitute the ban. Shortly thereafter, the Supreme Court overturned the appellate court's decision by an 8-0 ruling. According to Chief Justice John Roberts, a military recruiter's mere presence on campus does not violate a school's right to associate, regardless of how repugnant the law school considers the recruiter's message. And I must say, I don't know of any recruiter that would stand up and debate students in the circumstance of a policy judgment, more to the point in regards to a policy that is as controversial as don't ask, don't tell. They're there to recruit individual students or to ask or to answer questions that they may have. U.S. service members deserve our unfettered support as they face unimaginable dangers on the front lines in defense of our nation. Their willingness to sacrifice their time away from home and loved ones while serving in harsh and dangerous places under difficult circumstances should be honored. Seems to me we dishonor their sacrifices and service by hollow justifications of policy agendas, regardless of whether you think it's right or wrong. These efforts are a clear indication to me, as well as my fellow Kansans, that Ms. Kagan's agenda is at odds with her role as a dean and a future Supreme Court justice, and is clearly out of step with the average American, no matter how deep her concern, her empathy, her values, or the real world she believes she could or should change. So it is clear from her time as a policy advisor during the Clinton administration, a job that she truly relished, that she supports methods of enacting policy changes through administrative means and around the jurisdiction of the legislative branch, i.e. the Congress. This type of disregard for the jurisdiction of the elected branch of government is very concerning. Ms. Kagan's zeal and enthusiasm as a political advisor and an academic does not qualify her for a lifetime appointment to our nation's highest court. Not only does she lack experience on the bench, but her record clearly demonstrates a propensity toward pursuing an activist agenda. In her own words, Ms. Kagan confessed difficulty in taking off the advocate's hat to put on the judge's hat. This admission is at best worrisome, at worst a clear indication of her intent to legislate from the bench. We have a constitutional obligation to ensure that our judges are impartial and faithful to the law. During Chief Justice John Roberts' confirmation hearing, he noted that judges and justices are servants of the law, not the other way around. He said judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and judge is very critical and somewhat similar. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. They may go to criticize the umpire, but they don't go to see him. I am not convinced that Ms. Kagan will limit herself to merely applying the rules. Given the limited judicial background and a lack of forthrightness in queries to her judicial philosophy during the nomination hearings, I am fearful that this nomination will serve as another tool in what we have witnessed in further encroachment of government into the everyday lives of the American people. Kansans have made it very clear to me that they do not want activist judges on the court, and they do not want additional government intrusion into their daily lives and pocketbooks, especially coming from the bench. Unfortunately, I think appointing Ms. Kagan to the court will result in more of both. Therefore, I must oppose her nomination. Madam President, I yield the floor.